that my file has been confiscated by the Chief Justice of Uganda. But nevertheless, I'm working from a duplicate copy. I'll not be able to read everything in my ruling, but I'll make an effort to do what I can. As some of you who are here this morning know, the court convened with all the members of the quorum, and the Chief Justice directed that the rulings of the court would be read first, and then I would have an opportunity to read my ruling at the end. After the three rulings were given, the Chief Justice, who is the head and has been the head of the quorum, announced that the court was taking a recess and that would return in 30 minutes. To my surprise, when we convened after the break, I was informed by my colleagues that they could not join me to read my ruling, as I had done when they were reading the majority ruling. The reason they advanced is that I had not circulated my ruling for them to review. And my response was that we arrived at the decisions in all the rulings. We already arrived at our decisions. We already made the rulings. What is contained here are the reasons why we made the rulings that we made. While it is good practice for a member of the court to circulate their draft ruling to colleagues, there is no law in Uganda that I'm aware of that requires me to do so. I would have loved to circulate my draft to my colleagues before, but as you heard from the rulings, the 45 days that the Constitution requires us to finalize this matter constrained my ability to do so. Nevertheless, the whole court was aware of my decisions in each of the three applications that were called today. So I'm very surprised that the Chief Justice of Uganda has chosen to use barbaric means and to use his powers in the manner that he has chosen to do so. The Chief Justice had further directed me that my ruling will be read at a later date, that he would choose to appoint, and after he and the other members of the quorum had probably vetted my ruling. I found that order unconstitutional, and I chose to disobey it. When I was appointed a judge of this court in 2009, I swore to uphold the Constitution of Uganda, and I also took the judicial oath. And I am acting based on those undertakings I made. I felt it my constitutional duty to disobey the orders, the unlawful orders of the Chief Justice, and to fulfill my duty as a member of this quorum to deliver my decision within the 45 days that are required under Article 104. With those remarks, I will now proceed to read, in summary, my consolidated reasoned rulings. The petitioner, or before I go to that, Of course, on the directives of the Chief Justice, he ordered that all the microphones be switched off, that this tent should be closed, and I want to thank those who gave me directions to an open entrance. But even with this court being closed, this tent, which we turned into a court being closed, I was ready to read my ruling under the mango tree shade. So with those opening remarks, I want to now proceed with reading my ruling. The petitioner, Kyagulanyi Sentamu Robert, herein referred to as Kyagulanyi, filed this petition on 19 February 2021, challenging the outcome of the presidential elections that were held on 14 January 2021. He filed the petition against A, the first respondent, Yoweri Museveni Chibuhaburwa Kaguta, herein referred to as Museveni, who was declared the winner of the 2021 presidential election. Kyagulanyi was aggrieved by the declaration by the Electoral Commission of Yoweri Museveni as having won the 2021 presidential elections. On 1st February 2021, he filed presidential election petition number 1 of 2021, in which he made the following allegations. 1, that the elections was invalid on grounds that it was not conducted in accordance with the principles laid down in the provisions of the Constitution of the Republic of Uganda, the Presidential Elections Act, the Electoral Commission Act, bear with me, other relevant laws, and that the non-compliance affected the results in a substantial manner. 2, that the election was invalid on grounds that offenses under the Presidential Elections Act were committed by the first respondent or with his knowledge and consent or approval, and that the entire electoral process was characterized by security agencies, in brackets UPDF and UPF, committing acts of murder, causing grievous harm, violence, abduction, and intimidation against the petitioner. On 9 February 2021, I joined my colleagues on the quorum hearing presidential election petition number 1 to disallow Kyagulanyi's application, seeking leave to amend his petition to this court, where he had challenged the declaration of Museveni as the validly elected president in the elections that were held on 14th January 2021. I have since had the opportunity to read in draft the majority ruling of this court, giving the reasons why Kyagulanyi's application for amendment was not allowed. With all due respect to my colleagues, I do not agree with some of the reasons for the decision I arrived at with respect to the application for amendment of the petition. I'll begin with the law. I entirely agree with my colleagues that the law governing presidential election petitions in Uganda is found in Article 104 of the Constitution of Uganda, Section 59 of the Presidential Elections Act, and the presidential election (election petition rules made thereunder. Article 104 provides in the relevant part as follows. I will not read it in the interest of time. On the other hand, Section 59 of the Presidential Elections Act also provides for challenging the outcome of the presidential election in similar terms as Article 104 of the Constitution. I have not found it necessary to reproduce it here, with the exception of subsection 11, which provides thus: the Chief Justice shall, in consultation with the Attorney General, make rules providing for the conduct of petitions under this Act. It's clear from the above provisions that both the Constitution and the Presidential Elections Act require the following. 1, that a petition challenging the outcome of a presidential election should be filed by any candidate who is aggrieved with the result declared within 15 days from the date the challenged results were announced. In this particular case, the results of the 2020 presidential election were declared by the Electoral Commission on 16th January 2021. 2, that once a petition has been filed, the court should expeditiously inquire into and determine it and give its reasons for its findings not later than 45 days from the date the petition was filed. 3, the Presidential Elections Petition Act gives power to the Chief Justice in consultation with the Attorney General to make rules providing for the conduct of petitions. Turning to this particular application, it's not disputed by all the parties that Kyagulanyi, the petitioner, filed his presidential election petition on 1st February 2021. In their pleadings, some of the respondents contended that Kyagulanyi's petition was bad in law because it was filed after the expiry of 15 days from the date the election results were announced. It's indeed true that 1st February, when the petition was filed, was beyond the 15 days after the declaration of the presidential election results. However, it's also worth noting that the last day of the 15 days fell on a Sunday, which is not a working day. Secondly, the Chief Justice had not yet given directions for the court registry to be open on Saturday and Sunday, as is mandated under Rule 12(2)(c) of the Presidential Election Petition Rules. Nevertheless, in this case, the Chief Justice directed that the filing could be done on a Monday, 1st February 2021, and the petition was accordingly filed in court on that day. During the hearing of the application for amendment, counsel for Kyagulanyi relied on the following provisions of the law stated in the notice of motion. I will not read them. Relying on the provisions, counsel for Kyagulanyi contended that the provisions give power to the court to allow his application. He further relied on the following grounds briefly stated in the same notice of motion. 1, that the applicant filed a presidential election petition on 1st February and served it on the respondents. 3, I'm skipping some of that. Two, that filing of pleadings in the petition was still ongoing. 3, the amendment to the petition is necessary to enable this court to effectively investigate and completely determine all questions involved in the petition. 4, that the respondents shall not be prejudiced by the amendments to the petition. 5, that the proposed amendment to the petition did not raise a distinct cause of action in the place of the original. 6, that both the original petition and the proposed amended petition concern the same claim of right. 7, that it is in the interest of justice, equity, and fairness that the applicant be granted leave to amend his petition. Kyagulanyi's application was further supported by his own affidavit and an affidavit by his advocate, Tuliasima Geoffrey, and 2 supplementary affidavits sworn by him. In his affidavit of 8th February 2021, Kyagulanyi repeated the grounds in his notice of motion and further deponed as follows, and I've laid out what he said. In the said affidavit, Kyagulanyi deponed as to the reasons why he was seeking an amendment to his petition. The supporting affidavits of his counsel, Tuliasima, also deponed to the same facts, and the fact that counsel could not access Kyagulanyi at his home for 10 days after the election results were declared by the Electoral Commission. He relied on the decision of this court in Amama Mbabazi versus Yoweri Kaguta Museveni and 2 others, where this court allowed the petitioner to amend his petition. He also relied on other decisions of this court, which have. The applicant further relied on Rule 22, 44, 42, and 44 of the Supreme Court rules. I've not found it necessary to reproduce these rules. This is because Rule 21 of the Supreme Court rules provides that they shall apply only to appeals from the Court of Appeal. All the 3 respondents, Museveni, Electoral Commission, and the Attorney General, strongly opposed this application. Relying entirely on non-Ugandan decisions, the respondents contended that the Constitution does not allow for amendment of an election petition outside the 15 days a petitioner is allowed to file. Secondly, they contended that although the applicant's movements had been restricted for 10 days, he still had access to his lawyers. Thirdly, they contended that Kyagulanyi's restrictions did not affect his ability to instruct his lawyers to prepare and file his petition. Fourthly, they opposed the application on grounds that the amended petition was introducing a new cause of action, that is the alleged lack of qualifications of Museveni, the winner of the elections, to stand for and to be elected as the President of Uganda. I have noted in the majority ruling of this court that they agree with the submissions of the respondents. With all due respect to counsel for the respondents and my colleagues on this quorum, I do not subscribe to the alleged legal position that a presidential election petition cannot be amended after the expiration of 15 days, following the declaration of those results. As I noted earlier, all the respondents conveniently ignored the binding precedent of this court over Mama Mbabazi, where we allowed the petition to be amended. The respondents did not canvass this issue, nor the issue why the court should not follow this earlier precedent. While it is true that Article 104 of the Constitution and Section 59 of the Presidential Election Petition do not expressly provide for amendment of the petition, none of the said provisions expressly bar this court from allowing amendments. In the past, this court has jealously guarded the jurisdiction conferred on it by the Constitution and refused to allow arguments by parties praying to the court to hold that its jurisdiction was ousted. And I give an example of a case where this court declined 201 former employees of 4GS Security Services. This court declined to find that the jurisdiction of the High Court to handle employment matters had been ousted by the Industrial Court, which had not yet been set up for 5.5 years after the law was enacted. If this court declined to do so in a case where the law specifically provided otherwise, I would not subscribe to a view that this court's power to grant leave in proceedings before it could be ousted by a mere deduction that the power to amend is not expressly provided for. This court has always upheld its inherent jurisdiction to do justice to all parties as the circumstances of the case before it would warrant. In summary, I state that that is not one of the reasons I disallowed this application. Thirdly, the applicant also relied on Section 98 and 100 of the Civil Procedure Act, Rule 15 of the Presidential Election Petition Rules, and Order 6, Rules 19 and 20 of the Civil Procedure Rules. With the exception of Section 100, I found the remainder of these provisions applicable. Of particular interest is Order 6, Rule 9 of the Civil Procedure Rules, which specifically vests in this court power to allow a party to alter or amend pleadings, his or her pleadings. The rule provides as follows, and I've quoted it. The rule was applicable to a presidential election petition by virtue of Rule 15 of the Presidential Election Petition Rules, which provide that the Civil Procedure Act and rules made thereunder shall apply to presidential election petitions with such modifications as may be necessary. It's, however, important to note that while this court had the authority to allow the applicant petitioner to amend his petition, Rule 19 uses the word may, thereby giving the court discretion to grant or not to grant the application to amend. I will now turn to the issue of whether or not the application should not be allowed, because the proposed amendments would be introducing a new cause of action. The respondents contended that the proposed amendments of the petition, which was introducing the issue as to whether or not Museveni had the necessary qualifications provided for under the Constitution to be elected President of Uganda, was introducing a new cause of action after the expiry of the 15 days limitation period for filing a presidential petition. It is trite that the issue of persons who are eligible to stand for election as president is a matter of law. These qualifications are spelled out in Article 102 of the Constitution and repeated in Section 4 of the Presidential Elections Act. Section 102 provides as follows, and I have quoted the article, you can access it. On the other hand, Article 104 gives the right to an aggrieved candidate to petition the Supreme Court on grounds that the person who was declared as the winner of the elections was not validly elected. That being the case, the cause of action granted to an aggrieved candidate is to bring an action challenging the validity of the election of the successful candidate. I therefore do not agree with the respondents and the majority justices of this court that by the petitioner raising the issue of qualifications of Museveni, the winner of the 2021 election, or lack thereof, he was seeking to introduce a new cause of action. Contrary to the respondents' contentions and the majority of the court's view, I believe that the issue of qualifications of the president is not subject to the 15-day limitations rule. A petitioner or even any other person could have raised this issue before the presidential election was held or even after the elections are completed. In my view, a challenge to the qualifications or disqualifications of a presidential candidate cannot be extinguished on the basis of Article 104. Having been provided for in a separate article, it was my view that the petitioner did not, it is my view that the petitioner did not need to amend his petition. I'm aware of the provisions of Section 59(6) of the Presidential Elections Act, which provide as follows. 6. The election of a candidate as president shall only be annulled on any of the following grounds if proved to the satisfaction of the court. And B, 1 is non-compliance with the provisions of this act. If the court is satisfied that the election was not conducted in accordance with the principles laid down in those provisions, and that the non-compliance affected the results of the election in a substantial manner. B, that the candidate was at the time of his or her election not qualified or was disqualified for election as president. C, that an offense under this act was committed in connection with the election by the candidate personally or with his or her knowledge and consent or approval. I note that Parliament was granted power under Article 104 of the Constitution to, quote, make such laws as may be necessary for the purpose of this article, including laws for grounds of annulment. Pursuant to this section, Parliament enacted Section 59(6)(b), quoted above. Although Parliament was acting within the powers granted to it under Article 104(9) of the Constitution, the inclusion of the ground of annulment in Section 59(6)(b), without referencing Article 102 of the Constitution from where it is derived, led the unfounded view held by the respondents that a successful presidential candidate's qualifications can only be challenged under Article 104 of the Constitution and Section 59(6) of the Presidential Elections Act. I hold the view that a constitutional challenge based on the lack of qualifications of an elected president, as provided for under Article 102, can be made, 1, before the election is held, 2, during the presidential election petition filed under Article 104(1), or at any time after the 15 days have lapsed, 15 days under Article 104 have lapsed without a petition being lodged in the Supreme Court, or 4, after the conclusion of a presidential election petition. It goes without saying that such a challenge is not brought within such a challenge which is not brought within an Article 104(1) petition could be brought under Article 137 of the Constitution. I'm aware that my views above differ from the ruling of the court in this application, in which I concurred and where we unanimously ruled as follows with respect to this issue. Court finds that the issue of qualifications of the first respondent in the proposed amended petition is a new matter which comes outside the limitation period for filing a presidential election petition. Therefore, we disallow it. Having critically reviewed the constitutional provisions I have cited above, I have come to the conclusion that I arrived at a wrong decision to rule as above. While this is so, I'm aware that Article 132(4) of the Constitution gives this court a right to reverse itself in appropriate cases. It provides as follows. The Supreme Court may, while treating its own previous decisions as normally binding, depart from a previous decision when it appears to it right to do so, and all other courts shall be bound to follow the decisions of the Supreme Court on questions of law. I'm further aware that although this right is vested in this court as a whole, this article does not exclude the possibility of a single justice of this court to depart from a position he or she has taken earlier. This is especially so in a case like this one, where there is a decision of the whole court and where therefore there is no option for a reference from a decision of a single justice, as is in the case in the other cases where the court is exercising its appellate civil and criminal jurisdiction. Other than the above, I stand by the rest of the ruling of the court rendered on 4th February 2021. Having listened to the submissions of the applicant, I was convinced that he had made out his case that the restrictions on his movement by members of the police and army had adversely impacted on his ability to instruct his lawyers and to also prepare for his petition. I was further convinced that the applicant had been, quote, arrested in his house for 10 days by the police and the army, thereby losing 10 critical days out of the 15 days he was granted under the Constitution to lodge his petition to this court. The averments of Kyagulanyi and his counsel were validated by the order of the High Court issued in Kyagulanyi Sentamu Robert and Barbara Kyagulanyi Tungo versus Attorney General, Chief of Defense Forces and Inspector General of Police, High Court Miscellaneous Cause number 16 of 2021, where Elubu J ordered as follows. 1. The restriction imposed on the applicants are unlawful and their personal liberty be hereby restored. 2. The applicants comply with the COVID-19 SOPs. And 3. The respondents pay the costs of this application. In so doing, he expected the court not to interpret the Constitution but to apply its provisions. I still stand by the same views. So for the reasons I have advanced above, I find that I'm not bound to order Kyagulanyi to pay the respondents the costs of the withdrawn petition. The unconstitutionality of Section 61(4) of the Presidential Elections Act would by itself be sufficient to dispose of the respective parties' prayers on costs of this application and of the petition as a whole. That notwithstanding, I'm of the view that there are two other alternative grounds that support not awarding costs to the respondents. The first is that Section 61 and Rule 27 are declaratory and not mandatory. The operative provisions would have been Section 27 of the Civil Procedure Act, which I have quoted. Unlike Section 61(4) of the Presidential Elections Act, this section rightly preserved the discretion of a presiding judge to either award or not to award costs to a successful party. Hence, this section meets the constitutional test as it preserves the discretion of the presiding judge. But the more fundamental reason for declining to award costs to the respondent in this case is the issue of justice and fairness. The respondents argued that in the previous election petitions, this court has handled in 2001, 2006, and 2016, the petition was heard. They contended that this fact distinguished those cases where each party was ordered to pay their own costs from this one which was withdrawn. As I discussed earlier in this ruling, the respondents' prayer for costs to be awarded to them completely misses out the bigger picture about the nature and importance of a presidential election petition in our democratic governance. In Kano Kizza Besigye versus Museveni, Yoweri Kaguta and the Electoral Commission, election petition number 1 of 2001, Odoki, Chief Justice, articulated this as follows. This is not an ordinary case, but an important case involving the election of the President of the Republic of Uganda. It raises serious constitutional and legal issues, the answers to which and the reasons therefore need to be elaborately articulated for future guidance. The effect of the decision on the governance and development of the country and on the well-being of the people of Uganda cannot be overemphasized. Similarly, Justice Mulenga also expounded on this issue in similar terms. This court has established a practice of not awarding costs in presidential elections petition. There was therefore absolutely no basis for Parliament to stray into judicial territory and to make an unwarranted, predetermined distinction between withdrawn petitions and those that are fully heard. The established judicial practice in this country is not to encourage parties to continue pursuing litigation for the sake of it. Section 61(4) would seem to encourage that and also legislatively penalize in advance a petitioner who brings a petition to this court in good faith, but realizes midway through the process that it makes sense for a variety of reasons to withdraw it. This runs contrary to Article 104(1) of the Constitution, which does not qualify the right of an aggrieved candidate to challenge the presidential election result once such candidate believes that the declared winner was not validly elected.
What has happened today is unprecedented. As a practicing counsel, I was torn in between the gymnastics of court and the instructions of my client. But ultimately, my client became the Constitution. When I looked between the instructions of my client and the gymnastics which were at court today, I looked at the law and I realized that the justice of this honorable court, whatever she was doing, was within the law and was bound by the constitutional provisions that bind her or oblige her if she has a decision to read it out in public. It has been a court in the actual sense of the word, and we are happy that it has absolved us, especially counsel for the petitioner and applicant. We did not have the opportunity to talk about why we would not proceed with this petition. But if anyone read the decision of this justice of this court, will know that you cannot be a person accused, you disable the person who has accused you using force, and again benefit out of the illegality or unconstitutional acts that you've meted out against your opponent. That is what President Museveni has done in this petition. He has used the institutions of the state to make it very impossible for anyone to petition against him in this court, and we've been absolved. The difficulties have been properly laid out in this judgment, and we believe in it, and we are happy to have received this dissenting decision because it is the decision that we believe in. Nti ebizibu byadde byatuusibwako oyo gwe twayita mu kkooti ebyalemesa n'omusango n'ogenda mu maaso abantu abasinga badde babyogera kifuula nnenge. Naye kkooti ono omulamuzi alaze ensi yonna nti omuntu oyinza kubeera nga gwe bavunaana n'obeera nga weeyambisizza eryanyi. Ayogedde bulungi nti President Museveni yeeyambisa poliisi, neeyambisa amagye, neeyambisa ne ssente be butalina okulaba nti alemesa omusango guno gwa bannayuganda ogenda mu maaso. Ndowooza eyo nsala nnungi nnyo kaakati n'ogenda mu maaso, era tugikirizaamu y'ensala gye tukkiriza ey'amazima n'obwenkanya era egenda okuyamba enkola y'amateeka ogenda mu maaso bukwakku. Njagala bannayuganda bafune ensala eno bagyetegereze era ndowooza ne bannamawulire mujja kubayamba okubasomoleramu ebyo ebingi bye mulabye. Tubikkiririzaamu era tumwebaza okuba omuvumu okuba ku sayidi y'amazima okuba ku sayidi ya constitution kubeera kizzeemu lunye nti ye kyasinziddeko okukola kyakoze ge mateeka era tukkiriza nti ago ge mateeka gatambuliddemu.